All rise, please. Hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to this session of the Massachusetts Appeals Court. It is my great privilege to be sitting today with Justices Singh and Hand, and my name is Gabrielle Wolohojian. At the outset, I want to apologize for keeping you waiting. We had a technological problem that delayed us, so we're sorry about that. It had to do with our live streaming of this session. I'm just going to give you a couple of ground rules before we get started. Each side will receive 15 minutes to argue. We don't have rebuttal in the appeals court, and so don't reserve time for rebuttal because we won't be able to allow that. You can assume that we have read your briefs, the record. You don't need to use your time giving us the background. We know the background. Of course, you can construct your argument any way you wish. And I think that's probably all I need to tell you at the moment. With that, I'm going to call the first and the only case this morning, which is 2022 P1082, William FIALKOWSKI versus DONNA BALTROMITIS. And I understand it's Attorney McGlone who's going to be arguing for the appellant?
Yes, Your Honor.
Great. And you may want to adjust the microphone, and there's never any substitute for projection.
Thank you, Your Honor. Your Honor, David McGlone for DONNA BALTROMITIS, the appellant in this matter. My pronouns are he, him, his. May it please the court, I'll commence my argument. I don't want to get into a rote recount of the civil procedure, but it does inform and give structure to my argument. Basically, before I begin argument, to sum up what my argument is going to be, it's an avoidable judgment from another state, which was domesticated here via summary judgment or a 12C motion to dismiss. It's sort of unknown from the docket what exactly it is. And that has to do with, I think, a lot of the confusion from pleadings, perhaps confusion in the trial court. The trial court itself is a summary tribunal, which never held an evidentiary hearing per se, although the docket...
Well, it wouldn't require an evidentiary hearing on a motion to dismiss, correct?
That's correct. The docket does indicate that a hearing was held, and there is a due process argument here. But the docket, which was probably assembled during COVID, is sort of inaccurate. It lists the wrong party.
Let me just stop you before I think you go too far down that road.
Sure.
There are all sorts of hearings. You wouldn't have an evidentiary hearing on a motion to dismiss, though, correct?
That's correct.
You wouldn't have an evidentiary hearing on a motion for judgment on the pleadings, correct?
That's correct.
And you wouldn't have an evidentiary hearing on a motion for summary judgment?
That's correct.
Right. So are you arguing that there was an error somehow in not holding an evidentiary hearing?
Well, part of my argument is going to be that there was a document which was received, which would be the second notice of termination, and that was received as evidence and not a pleading. It was late to the party, so to speak. It was only brought after the motion to dismiss, and it was referenced in the trial judge's bench memorandum, which ultimately flowered into a judgment. So my point here is that there was essentially two different systems of procedure going on, one for the defendant and one for the plaintiff. The out-of-state judgment we'll get into that argument, I think is avoidable. But
Maybe we can pause there for a minute. So we have a general rule that you can't make collateral attacks on other judgments, which in some ways it looks to me as though you're trying to do here. So perhaps you could address that. But, and in there, I have a question about the record. I couldn't see anything in the record to indicate that that, and I'm just going to call her the wife, that the wife had raised the existence of the eviction moratorium in the Alabama court. Is that correct? If I'm not correct, please just give me the page number in the record so that I'll know what I missed.
I don't see any evidence on the record
Okay.
of that issue being raised in Alabama.
All right. And so if the issue was not raised in Alabama, how can you now raise it in a second collateral action to attack the Alabama judgment?
Well, this is not an action to attack. We're defending. A mere technicality, I understand. But Massachusetts does not have to follow this particular judgment from Alabama if it's void against public policy. And there are several other doctrines cited in our papers which indicate that at least it should have been regarded with caution, and that defensive pleading should at least have been allowed to be set up by the defendant in the housing court. So it's not a collateral attack on that judgment.
Well, if you're arguing that it's void, it is a collateral attack.
It's the state of
It's either valid and enforceable or it's not, right? So if you want to attack its validity in Massachusetts, you are making a collateral attack on that judgment, by definition.
It's not that black and white, because there are cases under the law of the Commonwealth wherein the orders and judgments of other states were not followed by the Massachusetts court nor domesticated. And those
Were they final?
Yes, I believe I cited a case wherein somebody from Connecticut was adjudged to be incompetent, and the Massachusetts court did not follow it, precisely for the same reason that the trial court should not have followed this court, because Massachusetts will look at the status of the person as they sit in the Commonwealth before they decide whether to domesticate or follow a judgment or give full faith and credit to a purported final judgment from another state.
So how does that help you here? Because if one were to look at the status of the wife, if at the time the case is brought in the Massachusetts Housing Court, the moratorium had ended. So how would that help you?
The moratorium had ended, but the landlord was under a statutory duty not to terminate the tenancy. So at that time, you have a defendant who's basically lost her rights because of another state enacting or issuing a judgment that was void in Massachusetts.
So why don't you point to me, if you don't mind, to any language in the moratorium that imposed any obligation on courts other than Massachusetts courts?
I'm not arguing that the Massachusetts legislature has the right to.
Right. In fact, the moratorium explicitly stated that it was applied only to Massachusetts courts. So if that's the case, just play out your argument for me as to why the Alabama court was in any way constrained by the moratorium.
The Alabama court was not constrained by the moratorium as far as its orders and actions went. And in fact, the Alabama court and I've argued in papers, could and did do what it needed to do as a tribunal to enforce its judgments and orders. And so it has brought contempt against Ms. Baltromidis, and it has ordered sanctions against other sanctions against her. That is.
So then, so now I'm having trouble understanding your position that the Alabama orders were void. Because if they weren't, you know, if the moratorium, I understood what your brief to be saying, that the Alabama court's orders were void because of the moratorium. They were issued during the moratorium.
Yes.
But the moratorium explicitly states that it binds only, it constrains only Massachusetts courts. And I hear you now to have acknowledged that. So if the Alabama court was not constrained by the moratorium and the Alabama court had inherent authority to enforce its own orders through contempt judgments, then on what ground, excuse me, does your argument that the orders were void rest?
Because it is void as against the public policy of the Commonwealth.
Okay.
And essentially ordered a resident of the Commonwealth out of her home, explicitly against the Commonwealth's policies. So the Alabama court, to the extent it had jurisdiction over that piece of property, and remember we have a piece of Massachusetts property, a Massachusetts resident, a dissolved marriage that was executed in Massachusetts, why wouldn't Alabama's order, why would somebody be in contempt, or why would a Massachusetts court enforce contempt when the legislature said that thou shalt not leave your house? No tenant should, no landlord should be able to evict or even request an eviction. And for Massachusetts to follow that judgment, which flies strictly in the face of what the legislature and the executive enforced, it is not bound to follow that judgment.
If I have my chronology correct, which I may not, because it's a complicated chronology down in the Alabama court, but if
Yes.
I have my chronology correct, and correct me if I'm wrong, the final order, the order entered on March 3rd, 2021 in Alabama, that was after the moratorium expired. Is that correct?
That is after the moratorium expired. However, the finding of contempt dates back from June of 2020 and then September of 2020. So this contempt.
Right, the moratorium expired in between the September 24th, 2020 order and the final evidentiary hearing, which took place on February 2nd, 2021.
Yes, my recollection is October 17th.
Right.
So
So you don't have an argument that the final order is void?
the judgment here is based on contempt. There is an argument that the final order is not even a final order, but we haven't gotten to that yet. So the contempt, in which I think there's another argument, the Alabama court's not finding the elements of a contract that have been breached, and therefore, or the elements of a tenancy that have been breached, and therefore you need to get out. The Alabama court is finding you in contempt for something you're privileged to do in your home state and where the residence is. And that has become the nut of the judgment that was enforced by the housing court. It is not a judgment on the merits, it's a judgment on contempt.
So I'm not asking you to concede anything, I'm just asking you to assume for the moment. Assume that we were to disagree with you about your arguments about the validity and the enforceability of the Alabama orders. Okay, just assume that for the sake of argument. What happens to the rest of your argument? In other words, I understand fully your argument that the judge leaped to the merits of, that there were due process issues concerning how the judge got to the results here, because there was a motion for judgment on the pleadings before the pleadings were closed, and on top of it, the motion was converted to one for summary judgment. I understand all that. So assume, though, we were to conclude that your arguments about the validity of the Alabama orders was incorrect, and also assume that what would then result? Because if those orders are enforceable, what would be the relief that you would be looking for?
If those orders are enforceable, we would still be seeking to file an answer, because this was not a situation where the way that judgment entered was not correct, because an answer was not allowed to be filed, because there was a confusion about whether it was summary judgment or a 12C.
Didn't the deadline for filing the answer pass before the filing of the 12C motion?
I don't think the housing court's rules prevent an answer from being filed.
They call for an answer to be filed within the 7 days of the Monday after the entry day, which it wasn't.
But a motion to dismiss had been filed, which would prevent a defaulting on that answer until that motion to dismiss was denied. When it was denied at the same time that 12C judgment on the pleadings was entered. So there was no time to file.
Are you relying on the rules of civil procedure, or is there a summary process rule that also, have we ever said that that same rule applies in the summary process context?
The rules of civil procedure remain unless specifically handled by one of the rules of summary process. So
The summary process rule says you have to file an answer within a certain amount of time. Why doesn't that end the inquiry there?
because it doesn't prevent you from filing a motion to dismiss, which will in fact trigger a non-default at the time of the return day.
Let me see if there are any further questions. So I take it the answer to my question was that you would be seeking a remand, even if we were to conclude that the Alabama orders were enforceable.
Yes, we would be seeking to interpose an answer, defend on what summary procedure was then to come, and then consider our options at that point. But there's no reason why rights should be cut off because it is deemed at this point that the Alabama judgment is valid.
Okay, I think we understand your argument. Your time has expired.
Thank you,
You'll
Your
have to take the rest on your briefs. Thank you very much for your argument. All right, is it Attorney Corner?
Good morning. May it please the court. My name is Mark Corner. With me is Lauren Bressman, and we represent the appellee William FIALKOWSKI. Very simply, there's no error here by the housing court, and there are really two primary pieces of the appellee's argument. First of all, the housing court properly afforded full faith and credit to the findings and rulings of the Alabama court, ordering Ms. BALTROMITIS to vacate the premises. And again, this all arose out of a divorce proceeding and an allocation of property. And in that agreement to allocate property, Ms. BALTROMITIS agreed to vacate the premises. She refused to vacate the premises, and she was ordered to vacate the premises by the court ultimately. I heard Mr. McGlone indicate that this was a domestication of the Alabama judgment. I don't think that's exactly what we're talking about here. We're talking about a Massachusetts court according the findings and rulings of a foreign court that heard and decided this issue on a matter in which this party, Ms. BALTROMITIS herself, submitted herself to jurisdiction. jurisdiction in the Alabama court. So this isn't really an issue here of domestication. This is an issue of applying full faith and credit to those to the findings and rulings in making the court's own independent judgment that Dr. FIALKOWSKI is entitled to possession of the premises. Second point, and I think it's been laid out here in the previous argument, is that the Massachusetts eviction moratorium, in addition to having expired, is inapplicable to the circumstances present here, because there was never any tenancy between Dr. FIALKOWSKI and his former wife, Ms. BALTROMITIS. As is indicated in the record, they own the premises on Fayette Street here in Boston as tenants by the entirety. It's one of several pieces of property that they own jointly through their marriage. And as part of this action, part of the divorce, there was a property separation agreement which was incorporated into the judgment of the Alabama court, indicating that she would agree to vacate the premises upon sale, and that the net proceeds of that sale, which still hasn't occurred, would be allocated on a 50-50 basis between the two of them. That agreement to vacate was incorporated into the final decree of the Alabama court, which was on May 28th of 2019.
You agree that no one notified the Alabama court of the existence of the temporary moratorium?
The record is silent on that point, so I would have to agree to that. I would imagine that would have been a defense that would have been raised by Ms. BALTROMITIS.
I don't think we need to worry about who would have been responsible for it. I just want to make sure I have the facts correct.
That's what the record seems to suggest, Your Honor.
All right. So can we turn maybe to the procedural issues presented by the summary process action? It seems to me that sometimes people move too soon for too much, and that may have happened here. So it is not, do we have any case, here I'm looking for a case site where we have said that judgment on the pleadings can enter before the pleadings are complete?
So on that particular point, I'm not aware of any particular case.
So this would have to be the first.
As far as I know, Your Honor, but what I will,
So when, and I looked carefully at the complaint, and I'm not sure, even if we were to assume that the complaint alone could form the basis for a motion for judgment on the pleadings, I didn't see that the allegations of the complaint itself were enough to get the judge to where the judge wanted to go, or did go, I should say. Correct?
I don't agree with that, Your Honor. Because it's a summary process case, there is a form, summary process, summons and complaint, which basically says that you are ordered to vacate the premises because of the findings and rulings of the Alabama court, which were appended to that summons and complaint, and the notice to terminate, which was also appended to the complaint. Those items alone, I believe, were sufficient to establish Dr. FIALKOWSKI's entitlement to possession of the premises. The response to that, rather than filing an answer, and there is, because this is a summary process, there is a form answer to that's promulgated by the trial court that says, okay, here's how you answer summary process summons and complaint. And no, that wasn't filed because Ms. BALTROMITIS made the decision as she's entitled to under Rule 12b-6 to file a motion to dismiss. Not in doing that.
So let's just stop right there. In that precise procedural posture, have we ever had a case where we've said it is not premature for a judge to decide a motion for judgment on the pleadings? There's a complaint, a timely motion to dismiss, and no answer filed.
Again, I'm not aware of a case that stands on all fours for that proposition.
All right, so then let's take another question. Are you, is there any case that you are aware of that says that in the housing court, in a summary process action, the ordinary rule that tolls the filing of an answer until a timely filed motion to dismiss is decided does not apply?
So, Your Honor, my understanding on that is that the rules of civil procedure provide an overlay to the rules of the summary process rules here, and I believe that a motion a motion to dismiss having been filed would toll the timing of an answer. However,
as long as it's timely, as long as the
sure,
motion
right.
to dismiss is.
But in this instance, it's important to note that in moving to dismiss, Your Honor, the defendant, Ms. Baltromidis, put all of the operative information arising out of she either put the information arising out of the Alabama court, either put it before the court herself, or it was contained in the complaint itself.
But she also argued prematurity. I looked very carefully to make sure that it was not a waived argument. She argued that it was premature, that she wanted an opportunity to answer, and that she had a pending motion to dismiss. And Judge, I don't think, but please correct me if I am wrong, doesn't seem to have addressed the procedural issues, right? Doesn't seem to have addressed that component of her argument. Is there something I missed in the decision?
I don't mean to not answer your questions, and I guess the answer to that question is I'm not aware of anything in the record that says that.
But the judge did say, I need to convert this motion to a motion for summary judgment because it refers to matters outside the pleadings.
That is correct.
Right. Now, that came up in the decision, but it did not come up, I didn't see in the hearing. I didn't see anything in the hearing where the judge indicated that that was on the judge's mind. And can you give me a page reference to the transcript if I missed it?
I can't. I'd be happy to follow up on that if you would like. But
I think we can go through it again,
Yeah,
but I didn't see one.
I'm not aware of that.
Right. So it doesn't look to me, to be frank, it doesn't look to me that the judge gave either of you notice that before the decision that converting the motion to one for summary judgment was a possibility in the judge's mind. At least I didn't see that. And no one argued it. You didn't argue it, that would be necessary. The other side didn't. But it just didn't seem to be on anyone's radar.
Well, Your Honor, if I may, if I could refer the court to page 42 of the record, volume 1,
Volume 1?
page 42, footnote 1. This is Ms. Baltromidis's motion, memorandum of law and statement of reasons in support of her motion to dismiss, and she expressly refers to the fact that under 12b-6 if matters outside the pleadings are brought before the court can under the rules, under either Rule 12b-6 or 12c, can convert the case to one for summary judgment.
Well, her argument was different in the footnote. She says you can consider them without converting a motion to dismiss to one for summary judgment.
That is true. That is true, but it also
But this is something different that happened. That is an argument that you can consider certain things without converting it to a different type of motion. What happened here is the judge said, I am converting it to a different type of motion. And that doesn't appear to me to have been, that doesn't seem to me that the court gave notice. We have cases that say, yes, that's entirely possible. Judge can do that, but the judge needs to give notice if that's going to happen. And that part I didn't see.
I'm not aware that that arose until she issued her decision, from which there was a subsequent motion to alter amend.
Yep.
So the issue was certainly eventually raised to the court, and I think correctly ruled in favor of the plaintiff here. And because what would an answer say? I guess that's what it, and setting aside the procedural niceties.
I don't know,
and
but usually you give the defendant an opportunity to decide that.
Sure,
You know?
but the fact of the matter is that she was in contempt of the Alabama order. There's no question about that. She had agreed to vacate the premises. There's no question about that. The only reason we ended up before the court here in Massachusetts is she thumbed her nose at her own agreement to vacate the premises and the court's order, from which she's in default to this very day. So that's the only reason why we're here. Why we are here. I think I think this is ultimately. I recognize the point, Your Honor, that perhaps there was a procedural miss by the court here. Ultimately, this is a case that in my view, that is resolved on summary judgment. There is no genuine issue of material fact here.
That may be correct. That may be absolutely correct. But a motion for summary judgment was neither filed nor opposed. No one got an opportunity to file it, oppose it, and for the judge consider it. And maybe that's all that happens. But I don't know.
And again, I think and setting all of that aside, there are no genuine issues of material no genuine issues of material operative facts, which are that she violated the Alabama court's order, and she has failed to comply with her agreement, which manifested as a judgment, to vacate, and that was never going to change. So if there were to the point of Mr. McGlone's point, well, we needed to file we needed an evidentiary hearing, we needed a trial. Ultimately, the facts are not going to change here. The facts are as they were pleaded. She failed to vacate the premises in accordance with the order. She was given notice prior to the commencement of the summary process case. She was given 40 some odd days on notice, more than she was ever entitled to here, and again, as the court, I won't rehash the argument, but as has been pointed out, well after expiration of the eviction moratorium, which again only applies to landlord-tenant relationships here. It doesn't apply to the situation here, where there is an allocation of a marital resource, a marital asset. That's basically on all fours with the Cabot case that was cited by the court, which basically says that upon the dissolution of a marriage, that the relationship does not become a landlord-tenant type of relationship. She simply was permitted to stay in the premises as a matter of law, pursuant to her rights as one of the owners of the property.
Thank you. Let me see if there are any further questions. No? Okay, I think we have your argument, both of you. Thank you very much. It's an interesting case, and we've been helped by your arguments, and we appreciate your coming in for them. Before you leave, I'm the chairman of the advisory committee on the appellate rules, and I have a quick question for you that I'm hoping the answer might help us in some things we're considering there. But did either of you use, I'm just going to call it AI, I know it has like a longer name of some sort, to assist in the preparation of any of your filings with the court? We're trying to consider whether we need to adopt any rule changes.
I have not, Your Honor. I wouldn't know how to do it.
Okay.
May I speak to that, Your Honor?
Yes?
After I wrote it, I put the same question into AI, and it gave me pretty much the same argument in more summary form. It made me feel good about my argument. I won't get into argumentation. It gave me one idea by analogy. but I use it as a cross-check.
And did you end up checking all the citations yourself after that process had occurred?
The only time it cited to me was procedural rules, and I did go back and look at those procedural rules. It didn't really give me case law. Sometimes if it gives you, if you have a case, you can put it in, and it may talk about the case a little bit. It doesn't really come up with common law too often, or from what I have seen.
Okay, that's very helpful, thank you. We have a disadvantage of being a bunch of judges who only know what we're told by lawyers, and so there wasn't an easy way for us to find out, but we hear things from other jurisdictions, and I really appreciate both of your candor. All right,
Thank you,
thank
Your
you. With that, the case is submitted, and thank you to our court personnel. We're going to be in recess.
Hold on, rise, please.